The next question will go to Ibidi. How are you?
I'm good.
Yeah. I have my attention has been diverted to someone else. How are you?
I'm good.
Okay. Welcome.
Thank you.
A few rules. I do not want to see the images of the children involved in this matter anywhere on our screens.
It's okay.
Okay. Let's go back. So that question goes to Mukidemi. Tell him to explain to us what he understands as the reason why he was brought in court.
Si kooban igu soo sheegay kulada waxaa ka aaminsan sababta ay tahay maxkamada ay joogto maanta. And saying you are close to also offensive committed.
What offense?
How I blood color? Yes, step on the blood.
Did he do it?
Must have been secular. Yes. Yeah? No.
Tell him to tell me what he thinks of the allegation that he is here in Kenya without proper documentation.
Middan oo sharci la'aanta waxaa ka dhigaya kulada inaad Kenya joogtid oo sharci aan wadid. And saying he was about to get his documents and then this offense happened.
Okay, tell him to sit down. So we start with Ibrahim's mother.
Very windy sound on my way.
She can tell us her name.
Maraan. Yeah?
Okay. Tell her the reason why we are in court is to determine how to deal with this matter.
So, maxkamadda aan u joogno waxaa waay leedahay inaan go'aansano keeskan qaabka aan
Then we have two options.
laba option aan haysnaa ilaa laba qodob.
One is through the criminal justice system.
Midka kow waxaa waay inay wadada oo sharciga waxaan ciqaabtii waxaas loo maro.
And the second one is through diversion,
Iyo midda labaadna waxaa waay inaan keeskan wadada lagu hayo aan ka wareejino.
where diversion is where we seek alternative remedies to include the offense.
Wadada markaan marayno oo wadadiisa aan bedelaynana waxyaalaha oo qodobada ay qorayaan inaan wadada aan wareejino baan raacayna ay leedahay.
Ask her whether she is agreeable if the matter was to be diverted.
Marka diyaar ma u tahay kuleedahay ku qanacsan tahay keeskan wadada uu hayo oo qaabtooda la marin lahaa haddaan kasoo duubno oo wadda kala aan marino oo aan xalin.
Vince mother. The same question to her.
Kuleedahay maxaa jirta ay kuleedahay laba qayb. Qayb waa wadadan oo qaabkii waxaas ay marayaan oo dembigooda lagu xakameynayo. Qaab kalena waxaa waay leedahay wadadan oo keeska la bedelayo oo xalinayna oo dhamaynayo. Marka qayb ku qanacsan tahay kuleedahay. Yeah? And then see if she's okay with the diversion.
Okay. Council, we have gone through the eligibility test. Maybe you want to comment
Yes,
on
ma'am.
whether they passed the test or not.
Yes, ma'am. And,
Briefly.
yes, ma'am. Of giving them opportunity to be processed through alternative means rather than the usual criminal justice system. And Your Honor, I've had my colleagues talk about Article 157, which which is very profound in terms of deterring criminal activities in the country in the interest of the public. And I'm also aware of Article 159 that allows these courts to neutralize the process of arriving at the solutions intended by the law, so that the courts have immense discretion to use this or that approach to achieve the ends of justice. In this case, Your Honor, I have had the report from the probation officer and the children's officer report. They are all pointing to the fact that in the circumstances of this case, Your Honor, the children ought to be given a chance to be properly conducted through diversion rather than the normal criminal justice system. Your Honor, public interest is extremely important, but under the Children's Act, the child's best interest is always superior. In any case, even where public interest is at play. And then I friend the powers of the DPP to charge and all that, and without, permission from anyone, which is true, Your Honor. That is the intention of the Constitution. But my learned friend will also wish to look at Article 53 of the same Constitution that allows all institutions, including this court, to uphold the best interests of the children where they are involved. It appears to us, Your Honor, that the writers of the Constitution intended to place children above actually any other law. And the manner in which the Article 53 comes out is as though, yes, there might be a mistake, even where there's a crime under the Children's Act. Again, where will the children go? It's not death or sentencing them, but applying alternative means to punish or rather correct the children. So, Your Honor, the best way is to look for any best method available to this court to reintegrate the children so that they are normal. And I must say at this stage, Your Honor, that the family has been extremely thankful to this honorable court in the manner in which the children have been handled and the way they have been made to understand their role from day one until now. So, Your Honor, we urge this court at this stage not to allow taking of a plea as that would make the public extremely happy, but could probably make children feel insensitive in the manner in which the adult society is handling them. If you allowed me just a few remarks, Your Honor, there is so much we can speak about Article 49, which has been already satisfied by the gesture from the court and the police as well, and the children officer who have treated the minors in the manner in which they deserve. So I don't want to go back to that. Thank you.
And I've had an opportunity to look at the reports that have been submitted by both the Children Office as well as the Office of the ODPP. Almost all the texts the minors have qualified. There is one where I'm not sure whether they have, that is whether they are first and second offenders. By virtue of their nationality, it is not possible to make that determination. So I cannot then say that strictly the eligibility test has been passed because of that one test that we cannot ascertain.
I'm sorry, it skipped my mind, the aspect of being foreigners. I'm sorry.
There are 6 tests
Yes.
that we are supposed to consider. The first test is the compelling evidence, which the prosecution says they have. The second test is whether the children are taking responsibility and they are admitting to the offense. The third test is whether the offense is a capital offense. None of them is. The fourth test is whether the parents are agreeable to diversion. They have both indicated that they are. The last test is we are supposed to consider the concerns of the victim, and that is where the issue of public interest. And the ODPP was now speaking, using both hearts, was speaking. So they have raised their concerns and we've looked at them. And the last test is the test as to whether the children have prior record. Now, that is where our challenge is. Due to the fact that they are not Kenyans, we are not able to ascertain their prior conduct. So then I cannot say then that the matter is fulfilling all the tests for diversion. And noting that there is that one test that has not been met, the alternative is the system, the criminal justice system. Okay?
Yes. Yeah. Can the DPP shed light why they cannot get the report of the children? Since the date the matter was mentioned in court and now, considering, Your Honor, that we have a working relationship with Mogadishu, we would like for the benefit of the young subjects to understand why they are not able to get any feedback
of today's session.
Your Honor, if we have already made the determination, and of course noting that, as we stated, we cannot get the previous records of this particular children, then diversion at this point would fail.
The other question that would also arise if the matter was to be diverted, well, now I am preempting the output, would be enforceability. Count. We all know that count.
being here illegally.
Yes. The fact that they are admitting that they are here illegally, it now raises the question, if we are to divert at this point, would mean that we are taking out the matter from court today. Would we then be repatriating them back or allowing them to continue staying and we condone their illegal presence? That would be the next question that would arise. That is why diversion would not work in this case. It has been squared out. Okay, so we proceed to plea taking, and I will read the charges. Of offensive conduct. Contrary to the law. The particulars are that I1M and MAA, that is their names in initials. On 20th of September 2025, while at a public place that is Nile National Stadium, which is within Nairobi City County, gently and offensively stepped on the Kenyan flag, desecrating it, and with the intention of provoking breach of peace amongst the citizens of the Republic of Kenya. It is true or not true?
You're kindly, because it's a children's matter. I have not had the occasion to inform our clients because the assumption was we were to take the reports, and I plead with the court to allow me to have a discussion with my clients for just 5 minutes without adjourning the court to alert them of the platform and scenario how it looks like once the criminal charges have been read. This has not been done, and I'm very sure they are not fully aware of the nature of pleading. I urge the court to allow me
I'll
to
give you
speak.
3 minutes. I
Yes,
believe that is why you've been instructed for this long.
Thank
You have taken them through the pros and cons of everything.
Yes,
so
Your
3 minutes it is.
Thank you.
With the offense of offensive conduct, contrary to the law.
dembiga koowaad waxaa ay leedahay inay wadanka sharciga ku xadgudubteen ama
The particulars are that the both of them on 20th of September 2025 while at Nyayo Stadium
labadiinaba maalinta 29 sanadka meel laba Nyayo Stadium
jointly and offensively stepped on the Kenyan national flag, desecrating it,
ku istaagtay inay leedahay wadanka Kenya calankiisa
and with the intention of provoking breach of peace amongst the citizens of the Republic of Kenya.
idinkoo kicinaysid xamaasad dara ka dhaca wadanka shacabka wadanka Kenya.
Ibrahim, is it true or not true?
Ibrahim run miyaa mise run maahan ku leedahay run miyaa ku leedahay dembiga ku aqrimayso waa qalad
Not true. Mohidin, is it true or not true?
run miyaa ku leedahay yes not true.
Second point. They are charged with the offense of insulting the national flag contrary to the law.
dembiga labaadna waxaa ay leedahay inaa lagaadib u geysteen camal wadanka calankiisa.
The particulars are that on 20th of September 2025 at Nyayo National Stadium,
29 sanadka meel laba Nyayo Stadium
they showed disrespect to the Kenyan flag by throwing it to the ground and stepping on it.
waxaa tusiseen xushmad darre leedahay wadanka calankiisa inaa turkiin oona ku istaagtay.
Ibrahim, is it true or not true?
Ibrahim run miyaa ku leedahay mise run maaha not true.
Mohidin, is it true or not true?
Idin run miyaa mise run maaha not true.
Did that count? They are charged with the offense of being unlawfully present in Kenya contrary to the law.
يعني dembiga saddexaad waxaa ay leedahay inay wadanka Kenya caajugsid idinkoo sharci la'aan.
The particulars are that on 25th day of September of 2025 at Islay Estate,
25 sanadkan meel Islay ah
being Somali nationals,
idinkoo shacabka Soomaaliya
they were found to be unlawfully present in Kenya without valid passes or permits allowing them to be present in Kenya.
waxaa ka arkayda wadanka Kenya idinkoo ayna haysan warqado mise visa tusinaya inaa wadanka joogtid.
Ibrahim, is it true or not true?
Ibrahim dembigaas run miyaa mise run maahan ku leedahay not true.
Mohidin, is it true or not true?
Not true.
In relation to bail and bond, we will take the terms that have been set briefly.
Yes, no objection.
ku saabsan leedahay boonka barnaamijka ujoogaya lacagta hore oo bixisayna weli yaalaysaa leedahay barnaamijka ujoogaysa.
In relation to pre-trial,
Yes, Your Honor, we will serve the documents that we wish to rely on. I can have a date for pre-trial and 2 weeks time.
That's fine. 2 weeks time is good, Yana, subject to getting the documents here from my colleagues. Then we can have 2 weeks. So if it's convenient to both sides, even in a month's time or 3 weeks maybe, just to be sure I get the documentation.
We can actually supply immediately after. So 2 weeks is sufficient.
2 weeks.
Then we mentioned the matter on 27th.
It is convenient to me.
Then we do the hearing 2 weeks thereafter. That will be on 10th November.
Your Honor, if you're available, is it possible to do it the week after? I'm requesting this because on November the 7th, did you say 10th or 11th?
I said 10th.
10th. Could we kindly push it to 12, 13 or 14? Because I will be, I have a function on the
You
8th.
start with the Mondays.
And
So if it is not 10,
Is it
it
convenient?
goes to 17.
it's convenient to do this.
17.
Yes.
So hearing on 17th of November. Now, I have some key and protection files that were opened for the 2 subjects. I prefer not to deal with them myself. I will advise that they go to duty court for them to be handled there. The key issue being their schooling. They can't stay idle. They need to be kept busy. So let the matter go before duty court for the court to give directions in relation to what they should be doing with their time in the meantime.
And I can proceed to duty court today. I'm actually doing it.
I'm dragging out the files to you. You can see they were placed here together with this file.
Yeah. Because of constraints of time, can we come back tomorrow or something?
We are not having cane protection matters had tomorrow, but immediately after impact, Honorable Choi is waiting for me to deal with others.
Okay?
Yes, that's okay.
There are certain issues that need to be addressed in
That's
the
right.
intervening period, including the harm the process is likely to inflict on the children. So we need to mitigate possible harm.
Most obliged.
So
Your Honor, is the TPP coming to that court again?
no, we are not part.
Because I was wondering how they can help in mitigating on a light touch.
Very, very